There actually was, for me, a pivotal moment in my thinking and what caused me to write the book. I was teaching the case of Buck versus Bell, and this involved a young woman who the state of Virginia ordered to be surgically sterilized. And the Supreme Court, in an 8-1 decision, upheld that order. And Justice Oliver Wendell Holmes wrote the most insensitive and offensive language in the United States reports, saying, quote, 3 generations of imbeciles are enough. When I was teaching that case to first-year law students, they were understandably outraged and upset by it. The night after doing so, I realized that I had been making excuses for the Supreme Court. And the more I thought about it, the more I realized that often in my teaching and sometimes in my writing, I had been making excuses for the Supreme Court. And that if I thought about it more candidly and more critically, the Supreme Court has often failed through American history, often in the most important times, often in the most important tasks. And that led me to decide I wanted to write a book that said that. If we're going to evaluate the Supreme Court, we can't ignore the fact that between the 1890s and 1936, a period of about 4 decades, the Supreme Court struck down over 200 federal, state, and local laws that were designed to protect employees, designed to protect consumers, really designed to protect all of us. And so during this time, the Supreme Court declared unconstitutional the first federal law meant to protect child labor, meant to make sure that children under 14 weren't used in manufacturing. For children over 14, says they couldn't work more than 10 hours a day or 6 days a week. And the Supreme Court found that unconstitutional. How many children were maimed or even died because of that Supreme Court decision? During the same period, the Supreme Court found laws that were designed to protect workers, like minimum wage laws, maximum hour laws, laws designed to protect consumers, were interfering with freedom of contract. And this is time when the Supreme Court was a tremendous obstacle to essential progressive legislation. And if we're going to make a case against the Supreme Court, it's very powerful evidence. The Roberts Court is the most pro-business Supreme Court that we've had since the mid-1930s. That's not just my opinion. A study was done by Richard Posner, a judge on the Seventh Circuit, William Landis, a professor in Chicago, and Lee Epstein, Washington University. And they found by a number of different measures that this is the most pro-business court we've had in 70-some years. In terms of what it means for all of us, it's a court that is favoring business interests over those of employees and consumers. To give one example, just over the last several years, the Roberts Court has said that people who are injured by generic drugs cannot sue. Cannot sue in state court, cannot sue in federal court, cannot sue saying there's a design defect in the drug, can't sue and say there's a failure to warn from the side effects of the drug. According to the FDA, over 80% of all prescriptions in the United States are filled with generic drugs. If there's a generic equivalent to a brand name, over 90% of the time, the prescription will be filled with a generic drug. And all of us who are injured by those drugs, even sometimes horribly injured, have no recourse. Another example is that the Roberts Court has systematically cut back on the availability of class action suits, strongly favoring sending matters to arbitration over going to court. The problem is when a large number of people each lose a small amount of money, it's a class action or nothing. A leading case at this was AT&T Mobility versus Concepcion that involved people who were losing $32 each. No one's going to sue or go to arbitration over $32. The Roberts Court has been very concerned about protecting defendants from large lawsuits, not focusing on the defense in these suits have been companies like AT&T and Walmart, the largest companies in American history. If they're going to be cheating people or injuring people, the only way to get a recourse is a large class action suit. There's no doubt that the Roberts Court has increased the political influence of large corporations at the expense of the rest of us. I think in hindsight we regard Citizens United versus Federal Election Commission as one of the worst Supreme Court cases in history, empowering corporations to spend unlimited amounts of money in their treasuries to get the candidates they want elected or the candidates they oppose defeated. At the same time, the Roberts Court has been weakening the political influence of unions through a series of decisions. That then increases the political influence of the most powerful at the expense of the rest of us. I think if we're going to look to the long term, we need to go back to the idea of economic justice is a basic civil right. I believe if the Warren Court had continued even a few more years, they would have been going in that direction. In 1973, just a few years after the Warren Court, in a case called San Antonio Board of Education v. Rodriguez, the Supreme Court said that poverty is not a suspect classification, meaning discrimination against the poor doesn't get any protection under equal protection. And in addition, the court said that education is not a fundamental right under the Constitution. If I could pick one Supreme Court case to overrule, I would probably point to that one, because we should regard discrimination against the poor as a violation of equal protection. And if anything is a fundamental right, surely it has to be education, because if ever we're going to close the gap between rich and poor, if ever we're going to be a more equal society, it's going to have to be through education. The most important thing in terms of constitutional law for the foreseeable future is who wins the 2016 presidential election. There are likely to be 4 vacancies at least over the next 8 years, maybe even over the next 4 years. And so it is that if a Republican can replace Justices Ginsburg and Breyer, then we will see things like the overruling of Roe versus Wade. If a Democratic president can replace Justices Scalia and Kennedy, then we can see the overruling of Citizens United and maybe even a court that will point towards economic justice. Now, putting that aside, and that's of course by far the most important thing for the court for the foreseeable future, I think there are structural changes that can be brought about. So for example, I favor 18-year non-renewable term limits for Supreme Court justices. I favor going to a method of choosing Supreme Court justices that's truly based on a merit system. And some states have merit selection. Jimmy Carter created merit systems for federal district court and federal court of appeals justices. He just never had a Supreme Court appointment. I think we can create a more meaningful confirmation process. I think we can change the way the Supreme Court communicates with the American people. To pick one example, there should be cameras in every Supreme Court proceeding. I think we need to change the ethical rules surrounding the Supreme Court. To me, it's inexplainable, it's just unexplainable, it's inexcusable why the ethical rules that apply to federal district court and federal court of appeals judges don't apply to the Supreme Court justices. It's to me inexcusable that we leave whether a Supreme Court justice is recused to that justice's own discretion. No person should be a judge of himself or herself.